Good morning, everybody. Thank you all for joining us. We have almost everybody in from the waiting room here. So I'm going to go ahead and get us started. And I'm going to start as I usually do with our Zoom housekeeping stuff. And we'll remind you that, first of all, we do ask everybody stay muted for the duration of the Q&A today. It just makes it easier to cut down on background noise and allows everybody to hear us clearly. If you would like to unmute yourself to ask a question verbally, you're more than welcome to do that. Just remember to mute yourself again when you're done. And if you're unsure, I don't know who's unsure anymore after all these years of using Zoom, but just to be on the safe side, your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device you're using. That's where you're going to find your audio mute and unmute button, as well as the start and stop video button. You're welcome to be on camera today if you want us to be able to see you, and you're also welcome to keep your camera off if you need to work or otherwise have privacy while you're listening to the Q&A today. The chat is the best place to put your questions for us during the Q&A today, and it might be flashing for you because I put a message into the chat, which tells you, number one, about putting questions into the chat, also gives you the information about where and when to send your questions in advance of each week's Q&A. So if you think of a question 3 days from now that you would like us to cover at next week's Q&A, please get it to us by Monday at 4 p.m. So that gives us the day on Tuesday to look at the questions, research, and provide our answers or prepare our answers in advance of each Wednesday's Q&A. Whenever we have too few questions in the Q&A, or if we have time once we get through the prepared questions, that's a better way for me to say that, we will get to whatever questions in the chat that we can cover today. And again, if we don't get to what you put in the chat, Chelsea keeps track of them, but also you can send them to that email address that my message mentions in the chat. As we remind everybody every week, we are not here to give legal advice for any specific community or specific situation. We're here to talk about general legal information that we hope is broadly helpful and applicable to communities in Washington state. So if you find yourself sending us a question that has specific details about, well, our documents say this, but then this document says that, or if you find yourself sending us, 2 or 3 paragraphs of details about a very specific situation you're dealing with in your community, we're probably not going to be able to answer that question. Chelsea will email you back and say, this is too specific for us to cover. Don't get mad at her. I'm the one that makes those judgment calls. So you can be annoyed with me if you need to. And whenever we can, we will try to make those questions more generic if we think that the subject matter would be broadly helpful to the folks that join the Q&A with us each week. But I did just have somebody tell me recently, a few weeks ago, that somebody was trying to tell them they were not allowed to do a certain thing because of something that I had said on the Q&A. So we remind you guys of this often. If somebody comes to you and says, you have to do this thing, or you can't do that thing because of something one of us has said on the Q&A, you can ignore them because this is not legal advice. It's just general information. I think as far as our housekeeping tips, that's about all I've got for you guys. The one last reminder that I'm going to put into the chat is a link for those of you who have not yet signed up to receive the Monday Morning Minute email. The Monday Morning Minute email is prepared by the chair of our Legislative Action Committee through WSCAI. And for those of you that don't know what the heck WSCAI is, their website is wscai.org. Chelsea, if you could put that into the chat, that would be great. Just the WSCAI website. They're a trade group that works with and on behalf of people who live in community associations. And our Legislative Action Committee has been working really hard behind the scenes with our many housing related bills that we're dealing with every year, but in particular lots this year. The Monday Morning Minute keeps you informed on what's going on during the legislative session. It's also a way that we will occasionally put out a call to action if there is, for example, testimony being taken on a particular bill that we think is, of specific interest to community associations. That might be where we say, hey, there's this hearing happening on this date at this time. Here's a link for how you sign in. We think you should testify in support of this bill or against this bill, whatever the case might be, and why. So it's a really good way to stay informed about what's happening with the legislative session. So with that, I'm going to jump into our first couple of questions. And again, as always, if you have additional questions you'd like us to try to get to today, you can put those into the chat and we will do our best to get to them if we have time. Our first question says, regarding the order in which to apply partial payments, in the January 29 Zoom meeting, Ken said, it will depend on the specific language in your declaration or CC&Rs. What should a board do if the declaration is silent on the matter, but the bylaws, which were adopted by the board, list a specific order for payment application? The short answer to this question is you do what your governing documents tell you to do, regardless of who adopted the amendment to that. And if your governing documents are entirely silent, then you have two choices. You can either just apply the payments to the oldest amounts due first, or the better choice, in my opinion, is to adopt a collection policy that specifies that you are able to apply them in that particular order. So a couple of caveats that are specific to this particular question. One is the question says the board adopted an amendment to the bylaws or adopted the bylaws, which dictate a certain order of application. That's fine as long as the bylaws provide that that's how the bylaws can be amended, right? So if the bylaws or the declaration say that only a vote of the ownership can result in an amendment to the bylaws, but the board adopted an amendment without a vote of the owners, then that amendment is probably not enforceable, right? So I'm not assuming that that's what happened here. I just want us to all be on the same page and understand that there are some documents, some communities have documents where the bylaws can be amended by a vote of the board alone. Other communities have bylaws which require a vote of the ownership in order to amend the bylaws. Another thing to keep in mind when you're looking at your documents and trying to figure out what controls on any question, not just this one, is that there is kind of a hierarchy of governing documents, right? If your declaration says one thing and then your bylaws say something different, the declaration controls over the bylaws. So if your declaration in this particular example had one order of how payments are applied and your bylaws said something different, the declaration would trump the bylaws and you would need to follow the language in the declaration. I also think it's worth mentioning that we have seen both bylaws and collection policies drafted by a particular firm in our practice area for a long time now that has a really specific order of application requiring that payments be applied first, for example, to payment of legal fees, and then to interest, and then to late fees, and then to fines. And only after all those other things do you then apply payments to the assessments, to the unpaid assessments themselves. So if you have any sort of really specific language like that in your documents, we would strongly encourage that you consult with your association attorney about amending that language and getting rid of it, because that language is not advantageous to the association in any way. One of the things that we think is a factor in support of just apply it to the oldest amounts due first. Number one, it's simpler, right? It's a little bit more straightforward. But number two, there is a statute of limitations for collecting unpaid assessments. For condos, for pre-Wakaiowa condos, it's 3 years. And for HOAs and Wakaiowa communities, it's 6 years. And if you're always applying payments to non-assessment penalties, like legal fees and late fees and interest charges and fines, but you're never applying them to the unpaid assessments themselves, you're letting those unpaid assessments get older and older and older. And while my preference would be that a debt never gets old enough that the statute of limitations becomes an issue in terms of your ability to collect it, I don't get to control the universe, sadly. And so sometimes that does happen. And that method of applying payments is not the best because of the statute of limitations issue. So I think that is an exhaustive answer to that question. But before I move on to the next one, I'm wondering, Tima, if you have anything you think that I should add to that.
No, I don't think so.
Okay, thank you. All right, here's our next question. What is the only legal reason for an HOA to not need a reserve study every year? The question is worded in a way that's a little confusing to me, but the short answer is that there are statutory exemptions to the requirement to have a reserve study. So the short answer to this question is, like, let's say you have a small HOA that has no reserve components that it maintains, or the flip side of that, a different exemption, the reserve study would cost more than 10% of your total annual budget. RCW 6490-545 is the section of Wakaiowa that talks about reserve studies. And it is one of very few sections of Wakaiowa that apply to everybody, including non-Wakaiowa communities. And what it says is that unless there is an exemption under subsection 2 of the statute, an association must prepare and update a reserve study in accordance with this chapter. And it requires that initial site visit, like on-site full reserve study every 3 years. And then in the 2 intervening years, you have to update the study. And subsection 2 of the statute says that the reserve study requirement does not apply to, well, if it's a common interest community that has units that are restricted to non-residential use, but that's not the case for the vast majority of the folks that are on this call. The other 2 exemptions would be if you have only nominal reserve costs, or if the cost of the reserve study or update exceeds 10% of your annual budget. And the statute does define what nominal reserve costs means. So this isn't a thing where there's a term in the statute and it's undefined, and so you get to decide what it means, right? Wouldn't that be nice? There is actually a definition in the statute, and essentially what it boils down to is you have next to no reserve components that you maintain as a community. So the translation here is that most associations are required to get a reserve study every year, and most associations will not qualify for the 2 limited exemptions that are in the statute. If you have a community where you have your board has not had a reserve study for a period of time, there is a provision within the HOA Act which allows the owners to essentially demand that the board include the cost of a reserve study in the next budget. And the statute, if you want to look at it, is 6438-080. That's for HOA Act communities. So that's not really relevant to the question, but just an interesting aside in case this might be something that you're dealing with in one of your communities. Tima, did you have anything you wanted to add?
No, I don't.
Okay.
The third question is, I would imagine that most condominium communities have limited guest parking, and most communities are private roads. With that said, can an HOA rent out various parking spots to owners? Isn't an HOA community owned by all homeowners and should be treated fairly? So the question is about what's fair. And to answer that question, the answer to that question is that an association can regulate the use of parking, common parking spaces, and that would include the ability to rent them. Yes, the process needs to be fair, but charging rent doesn't necessarily make it unfair. So it's just going to be, and again, you want to go back and look at what exactly your governing documents authorize as far as parking and what the specificities are for that. By association, not only can an HOA, if authorized by their governing documents, charge for parking, they can also fine homeowners for parking illegally if their documents authorize that. An HOA can also charge owners for special types of parking spots, for example, trailers, RVs, oversized parking. Again, those spots would be, as long as the governing documents authorize that, the association can charge those fees. I don't have anything further there. Do you, Valerie, want to clarify on anything I've said?
Nope, I think you covered it.
Okay. The next question is, if a board conducts a vote on an action item while in executive session and there is no other evidence of said vote, is it valid, and what can a person do about it? The short answer to that question is, if a vote is taken in executive session, it needs to be taken again in an open meeting in order for that action item to be authorized. For condos that don't have open meeting requirements, the vote should be taken in the regular board meeting, even if it's not an open meeting, and should be recorded in the minutes. One thing to keep in mind is that if you've done things incorrectly, you can go back and ratify a past decision by making the minutes reflect them and provide the evidence of the past vote that was taken. So if you realize after the fact that you did things improperly, you can go back and correct it by recording it in the minutes. Let me see. I think I've covered that answer. Valerie, do you have any other comments on that one?
Yeah, the only thing I just would emphasize is, we have a lot of clients or communities that I think misunderstand the intent behind executive session. Executive session is intended to be limited to a pretty short set of subject matters. Delinquencies, for example, are not included on that list in the statute. A lot of communities think, oh, we can only talk about delinquencies in executive session, and that is not accurate. I understand the sort of tendency to think that way, and I definitely respect the desire to not have like a wall of shame approach to delinquencies where you're blasting out owners' information when they are struggling to pay their assessments. But the way that you handle that is you talk about the delinquency in the open board meeting and just refer to it by account number rather than by the unit owner's name or the unit number, right? Executive session, even when the subject matter you are discussing is appropriate for executive session. The idea behind executive session is that it provides a private venue for the board's discussion on certain topics, but then you reconvene your normal meeting, whether it's an open board meeting or a closed board meeting, you're still supposed to reconvene the board meeting. That's where you then make your motions, take your votes, and record those decisions in the minutes. So I think some of this just comes down to a lack of understanding of what executive session is for and how it's supposed to function. You're supposed to start in a regular board meeting, adjourn to executive session, discuss your very small list of items that are appropriate for executive session, and then reconvene your regular meeting. And that's when you make your motions, take your votes, and record the minutes. So I don't know that that's anything different than what Tima just said, but maybe just a different way of articulating it if that's helpful for some people. And I'm going to move us on to our next question. RCW 649510, subsections 10A, B, and C. Please clarify what they mean. What can we restrict regarding short-term rentals? What kind of rules can we adopt? Our HOA plat governing documents are totally silent on rentals. We have not yet adopted Wakayawa. We are considering restricting short-term rentals to 30 days. We currently have several. Are they grandfathered in now and or later? So I'm going to start with an aside, which is that the use of the term grandfathered in is something that we're trying to get away from in our industry because it has racist origins. And so if that is something that is of interest to you, you can Google it and learn more about where that term comes from. And so I don't know fault to the person who submitted this question. I still struggle sometimes to think of a different term to use. But the question essentially is, under this particular statute that the person cited in the question, what is the association's authority to regulate or maybe even prohibit short-term rentals? And are currently rented properties exempt from any new regulation that the association might adopt under this statute? So I want to start by saying that we cannot give you legal advice for your community. So I'm going to talk generally about what this statute means for plat communities, single family home HOA communities, but I'm not going to answer this question for your community, and I just need to make that really clear. But the short answer to your question is that most likely this statute does not give you the authority to restrict short-term rentals unless you amend your declaration to specifically give you the authority to do that. That's the short answer. Each of the sections of this statute that you asked about, they say something different. So subsection 10A says you can make a rule to implement something that's already in the declaration. But if your declaration does not already limit short-term rentals, then you can't make a rule limiting short-term rentals. Subsection 10B says that you can regulate occupancy that violates the declaration or adversely affects the use and enjoyment of others. But you would have a difficult time demonstrating that all short-term rentals adversely affect anyone, especially in a Plat community where you're not, sharing like hallways and walls and whatever. And in particular, when you have other methods of regulating whatever that negative impact might be. So let's say your concern is parking or noise or something else like that. As an HOA, you have the authority to adopt reasonable rules limiting those types of impact on the community as a whole, short of banning short-term rentals, right? Subsection 10C is the last part of the statute that you asked about, and that says that you can restrict the leasing of units only to the extent that the banking industry will not loan money to purchasers or owners refinancing because of the number of rentals in the unit. So in other words, if the banking industry, basically Fannie Mae and Freddie Mac, if they won't loan within your community because you have too many rentals, this is a scenario, and this is only applicable for Wakaiowa communities, in which a board could adopt a rule limiting rentals to something less than whatever that percentage is, where beyond that, Fannie Mae and Freddie Mac won't loan within your community. Right now, that's 50%. We know for condos, not Plat communities, condos, banks limit the number of rentals to 50% of the units. If you get past that 50% number, that's where you start to have trouble getting financing. We have had one client at least take advantage of this particular provision in Wakaiowa, allowing them to adopt a rule capping rentals at no more than, I don't know whether it was 49% or if they actually let it get to 50%. So we have had a client do that. It does work for Wakaiowa communities. It probably would not work for a Plat community. It's probably only going to work for a condo. Because the lending restrictions are not the same in Plat communities as they are in condominium communities. So I think that answers the question. Short version is you probably can't do anything. You probably have to amend your documents. But if you want the actual answer for your particular community, you need to go consult with your association attorney. Tima, did you have anything to add before I jump to the next question?
No, I think that covers it, Val.
Okay. Next question. We recently adopted following Robert's Rules of Order and open board meetings. And in researching meeting minute guidelines, it does indicate that if a vote uses yays and nays, then the secretary, quote, should enter a list of the names of those voting on each side. What is the recommendation when it comes to recording how each board member or owner votes in this scenario, assuming it's not a secret ballot? So I think, the answer probably varies a little bit. I mean, is it a board meeting? Is it an association meeting? That is one difference where things might be a little bit different. And for all meetings, I think where I would want to start is reminding everybody that the statutes trump Robert's Rules of Order, even if you've adopted Robert's Rules of Order for use within your community. So the statutes, when they say things like votes on these particular subject matters, for example, are confidential, if Robert's Rules of Order says you should put a list of how every person voted, the statute's secrecy provision trumps, or confidentiality provision trumps, what Robert's Rules of Order suggests in that scenario. Also, there's other statutory provisions that sort of dictate how or speak to how minutes can be drafted to reflect the way each person votes. So in particular, in board meetings, for example, there's a statute that says a board member can ask to have their no vote specifically reflected in the minutes, which to me would suggest that you're not otherwise tracking how every single individual board member votes. So if you look at RCW 6490 445 subsection 2L, that is the one where it says a board member who is present at a board meeting at which any action is taken is presumed to have assented to the action taken unless the board member's dissent or abstention is lodged with the person acting as the secretary of the meeting. So in other words, if you are present at a board meeting and an action is taken, you are presumed to have agreed with or voted in favor of that action, consented to that action, unless you specifically ask the board secretary to note in the minutes I abstain, or I'm voting against this, right? So I think also, as a little bit more of an aside, I think Robert's Rules of Order can be instructive and informative to people who have never run a parliamentary style meeting before. But I think for most of our clients, following them to the letter all the time for everything ends up being way more complicated than you need board meetings to be. And so that is something that I would keep in mind. I mean, it might be a day late and a dollar short for this particular community, which has already voted to adopt Robert's Rules of Order as their sort of guiding structure for board meetings. But I do think often they are a lot more complicated than they need to be. I'm going to also point out RCW 6490-455 subsection 9 is the part of Kiowa that talks about confidential ballots and when certain types of votes are to be kept private, not to be disclosed. So under a roll call vote, for example, if you were doing a roll call vote, you would record all of the unit owners that showed up and then how they voted on each item, right? But then if you've got a confidentiality provision in the statute, that trumps the way you would normally handle a roll call event. So the short answer to this question is it kind of depends on what type of meeting we're talking about, what it is that you're voting on, what the statute says about that particular type of vote. And if you're not indelibly tied to Robert's Rules of Order as a whole, you might be better served as a community by using Robert's Rules as guidance as opposed to law, essentially, dictating in every respect how your meeting should be run. Tima, did you have anything to add to that one?
Yeah, I would simply add that, adopting the Roberts rules is, again, like Valerie said, it's a guideline. It's not any type of requirement. And the rules that you adopt should serve you and should serve the association. So just think of it from a practical standpoint, and you can use the Roberts rules to the extent that they help you, and you can not use them if they don't. So it's not a hard and fast rule, and there's things that might be more practical for you to use and some that might not be. So
thanks, Tina. All right, next question. I think there might have been a question about this in the chat too. Please offer any comments relating to House Bill 1501. So it was interesting when we were doing the prep for this. Ken's comment was, we don't know why there is an obsession right now in the legislature about owners' rights to records and to participate in meetings. And I just have to chuckle a little bit because that is very much a theme in the legislative session, but not just this year, last year and the year before. Last year, the sort of nickname for the legislative session was that it was the year of housing. And honestly, I can't see how this year is any different because of the volume of bills that speak to housing generally, but also there's a pretty significant volume of bills that are specific to common interest communities in Washington state. 1501 essentially introduces these new requirements where if an owner sends a certified letter to the association asking about certain things, then the association has to respond within 30 days, like substantively. They have to actually answer the questions or the concerns that are raised in the letter. And if they're not going to provide a substantive answer, the only valid reason under the proposed bill, let's put it that way, it's not a statute yet, is you can respond within 30 days to say, we're consulting our attorney, we're getting a third party opinion about this. And in that case, you have 60 days to respond. I think one of the things that I keep thinking about as I have reviewed this bill, there's other bills, including one that proposes to mandate mediation between associations and homeowners before an association can do a foreclosure lawsuit of any kind. There is a perception in Olympia that there is a problem. There's a communication problem between homeowners and associations. And I think just like anything else, the stories that the legislators hear, the stories that we all hear on the news, and even to some extent, the stories that make it to our office when people call us for help are the outliers, right? One of the things that I try to remember and that I occasionally point out when I have conversations with people who are sort of frustrated with associations in general is that CAI National did a poll, I think 2 years ago, maybe, and something like 87% of the respondent homeowners were largely happy with their community association, which is an overwhelming majority of people who were happy that they lived in their HOA or their condo association. They thought it was well run, and they thought, they thought it was a good deal where they lived. And yet what we hear most often in the news, what we hear sometimes when people call us in a panic asking for advice about a situation, and certainly what the legislators are hearing, are the sort of minority horror stories where, because it does happen that an owner tries to communicate with a board and they just get stonewalled, right? So what's happening, I think, is that a small percentage of these scenarios are sort of the brush with which all community associations are being painted. And so bills like this are trying to fix a problem that largely doesn't actually exist, but that there is a perception that it exists. There's a perception in Olympia that owners ask their associations questions and the association just doesn't answer, refuses to provide them with records, refuses to give them copies of the board meeting minutes, or whatever the case might be. So I think that's the problem that this bill is intended to fix, is enforcing a statutory requirement and timeline for board responses to homeowner complaints or questions or concerns. It does allow associations to establish reasonable rules about the frequency and the manner in which they respond to these types of inquiries, including a limitation of one inquiry per lot or unit owner per 30-day period. I'm not really sure I think that that's all that reasonable limitation, because that could still mean in a community of 100 homes that 100 people could send you a certified letter every 30 days for the entirety of the year. So 100 times 30 times 12. I don't want to do the math. Somebody else can do it for me. But that's a lot of letters that then the board is forced to respond to in a specific way in a community where maybe there's only a communication problem with one or two owners, right? So I think it's a disproportionate response to a relatively small problem. That being said, that's what the bill is. If you have additional questions, you're welcome to pop them in the chat. This is a really good reason why you should be registered for that Monday Morning Minute email. You should be getting the legislative updates from CAI. And anytime these bills are scheduled for a hearing in front of whatever respective committee is reviewing the bill, you have the opportunity as residents of Washington State to sign in and testify either in favor of or against a particular bill, and to tell your story to the legislators that are considering the bill. So I would really strongly encourage people, not just with this bill, but with all of the bills that are relevant to community associations, to try to make your voice heard in whatever way you have the capacity to do that. So I think that's everything on that topic. And so Tima, you can take it away with our next question.
So the next question states, we are an HOA. Our bylaws specifically state the annual association meeting notice must be delivered either by hand or by mail to homeowners. It is silent on the subject of a call for director's notice. Is there any reason we need to follow the same delivery requirement? We only started sending a call for director's notice out 3 years ago and have done so by US mail, which is expensive. We would like to switch to email. The short answer to this question is, under the HOA Act, notice provision specifically states, notwithstanding any inconsistent provision in the governing documents, notice to the Association of Lot Owners Board or any lot owner or occupant of a lot under this chapter shall be in writing, shall be provided by either personal delivery, public or private mail, or by electronic transmission as provided in the section. So you can use email as long as it specifically doesn't say that you can't. So, or specifically says that you can't. So, if there's a different notice requirement that in your governing documents, you need to follow that. But otherwise, there's no reason why you shouldn't be able to switch to email.
I'm going to interject one caveat.
Yeah.
Email notice is opt-in only.
Right.
So you cannot force your owners to accept email notice, electronic notice in place of paper notices sent by mail. Just like they can't force the association to accept electronic notice instead of a written notice sent by mail. So
Yes.
team, you're absolutely correct that even if the documents say that the notices can only be sent by mail, email is definitely an option, but only for those owners who opt in to receiving electronic notice.
Right. And for this specific question, you're asking about the directors. So if all of the directors have opted in to electronic notice, that's going to be fine. But you can't violate any contrary provision in your governing documents as far as notice is required. Valerie, does that cover it, do you think?
Yeah, I think so.
Okay.
Some of the comments about, this subject generally, like the call for director's notice. If you have nominations from the floor, the risk of sending the notice by email is pretty low because notice is not required in that scenario. If it's the only way to solicit board members, or if you're voting by mail, we would recommend then delivery by mail to those who haven't opted in to receiving electronic notice.
Yes.
And one way that you might address the cost issue is if you're spending a lot of money every time you're sending out a mailing, for example, to your entire ownership, right? Because you have to give notice of these meetings to all of your owners. Maybe spend a little bit of effort and money on soliciting as many electronic notice opt-ins as you can, so that you reduce your mail cost over time as more people opt into electronic notices.
Yeah, that's right. I mean, you can take a proactive approach so that you have that documentation in place, and then moving forward, you don't have to check each time who's opted in and who hasn't.
Right.
So you'd have to document it, but as long as you've documented who's opted in, it should be very clear where you can use email and where you still have to use regular USPS mail. So it should still reduce your costs overhead because some people will opt in. Let's see. The next question is, when and how is it appropriate to correct minutes from an annual association meeting? An owner is asking that a clarifying detail about the budget be added as a correction to the minutes from our annual meeting. So to answer, first of all, the short answer is that you would need to, first of all, if you have draft minutes in place and you haven't approved them yet, those can still be edited before they're sent to the owners for approval. So if you're just talking about, when you say correct, I guess I'm not exactly sure what you mean by that, but I'm assuming what you're saying is we haven't yet approved them. We want to make a revision upon the request of an owner. And that's the way we would recommend handling it. Then once you're at the meeting, you can make a motion to accept the minutes that have been revised and sent to the ownership. Otherwise, you can present the revised minutes at the meeting and move to amend the minutes at the meeting and then record that. But in order for any change to take place, you would still need to vote on it at the next meeting. So I don't know, did I fumble that? Valerie, does that make sense? Did I say that clearly?
I don't know, but I'll just rephrase. I'm going to start with something that you didn't say yet, but I think is like the overarching thing we need to remind everybody. The membership as a whole gets to decide if the minutes are adopted as they are drafted or as they are amended or proposed to be amended, right? By whoever's making the proposal. So, and going back to the question, it says, when is it appropriate to correct minutes from an annual association meeting? An owner is asking that a clarifying detail about the budget be added as a correction to the minutes from our annual meeting. So if this is your annual association meeting, the way you approve minutes each annual meeting or each association meeting, let's put it that way, because there might be meetings in between the annual meetings, is that the draft minutes are provided to the owners in advance of the next association meeting. And at the next association meeting, the minutes are approved, revised, or otherwise, right? One owner can ask for a revision or a correction, but they cannot force that on the ownership, and they don't get to decide by themselves because it's the entire body that gets to vote on whether the minutes are adopted or not. So I think that answers this particular question. And then I'm going to go ahead and take us into the next questions because these are also related to minutes. So when does an HOA approve the minutes from their annual meeting? At the next board meeting or at the next association meeting? And so I think I already answered this, but I'm going to restate it again, which is the minutes are approved at the next association meeting. If we're talking about board meeting minutes are approved at the next board meeting. If we're talking about association meeting minutes, those are approved at the next association meeting. That there is some, not ambiguity necessarily, but some interesting quirks introduced because of this scenario. So let's say you live in an HOA community under the HOA Act, and you have one association meeting per year, but your board meets every month. There is something in the statute that requires that minutes from the annual meeting, from the association meeting, be made available to owners upon request within 60 days of the meeting itself, which means you're essentially required to provide the owners with the draft unapproved minutes from that association meeting, because those meeting minutes are not going to be approved until you have your next association meeting, which might not be for another year if you only have one per year. So the board could, at its next board meeting after an association meeting, look at the minutes from the association meeting, say, yes, these look accurate. These are going to be the draft minutes that we provide if people request them, so that we're complying with the statute. But the board doesn't approve them. They don't become approved in official minutes of that association meeting until the next association meeting, when those minutes are approved by the ownership. So hopefully that's not too convoluted for y'all. And I'm going to keep us moving, because we do have more minutes related questions. Are minutes taken at an open board meeting that is not a regularly scheduled HOA meeting? I find this question, I can answer this question, but I'm also a little confused by this question, because I mean, there's two parts here, right? Are minutes taken at an open board meeting? Yes. Period. End of story. Yes. Any board or association meeting where business is being done, minutes should be taken. If you establish quorum and you're going to go through, old business, new business, vote on stuff, whatever, that's a meeting, and you should be taking minutes, whether it's a board meeting or an association meeting. This is true of open board meetings as well as non-open board meetings if you're a community that does not have that requirement yet. Okay. Minutes are the record of the actions taken by the board or the association at that meeting. And if you don't have minutes, then how do you prove what happens? Right? One of the things that those of you who have been participating here long enough have heard me and Ken say probably dozens of times. I'm almost tempted to like call on somebody and have you unmute yourself to say, if it isn't written down, it didn't happen, right? So if you don't have minutes from your meetings, how the heck do you document what you voted on and what actions were taken at that meeting? The part of the question that I don't understand is, it says, are meeting minutes taken at an open board meeting that is not a regularly scheduled HOA meeting? I don't think I really know what that last part is, what you mean by that. But maybe I answered your question anyway, because I just said a whole lot of stuff about minutes and meetings. If I didn't, please put a request for clarification in the chat, and we'll try to get to it before the end of the day today. Tima, back to you.
Okay, the next question. What is the process for collecting HOA fees that are in arrears when the unit is being sold? I will start out by saying, without knowing any specifics about this particular matter, I'm only going to answer it generally. My first question would be, have you already referred the account to us or to your association attorney for collections? If you've already done that, I would assume or predict that there is already a demand letter that's been mailed, or a lien that has been recorded, or both. In the event that that has not happened, and you as an association are, you've allowed, there's been some accrued debt, unpaid assessments in this owner's account, you've now discovered that the property has been listed for sale. The first thing you should do is reach out to an association attorney and ask for their advice. To answer this question, I think in that case, what we would recommend, or what most association attorneys would recommend, depending on how much time is, time would be the question. If you've discovered that the property is listed for sale and is actually under contract to be sold within 2 or 3 days or 5 days, and you have a very short time period, at that point, probably your best solution would be to record a lien as quickly as possible. To whether or not you have an automatic lien, it's a good idea to go ahead and record a lien covering the amount that's owed. And depending on how much information is available, either you could record it yourselves or you could have your association attorney record it for you. Then what would most likely happen in this case is that when the title team, the escrow team, the closing agent is preparing the closing documents, they would reach out to you, the association, for a payoff ledger in order to have that lien released at closing, and the balance would be paid at closing to the association to cover the amount owed, at which point the lien can be released. Again, there's a lot of things I don't know specifically about this question. I'm answering it in a very general way as to the advice we would give anyone, just based on the question as it's being asked. Valerie, do you have any additional thoughts on that?
Yeah, one thing I will say is the answer to this question can be a little different when you're a single family home HOA versus a condo or a Wakaiowa community. Because if you live in a condominium or a Wakaiowa community, your community has a resale certificate requirement, and a sale should not be able to occur without a resale certificate being requested. And when a resale certificate is requested, one of the questions on there is whether there's a delinquent balance due that needs to be paid at closing. If you're a single family home HOA under the HOA Act, you don't have a resale certificate requirement. That's one of the things that's going to change when everybody becomes subject to Wakaiowa. And I think that's going to be a really significant benefit for HOA Act communities, which will now have a resale certificate requirement when they did not previously, or when they do not now. I have seen properties sell in HOAs without the lien being satisfied because no lien was recorded in the public record and no resale certificate was provided because none was requested, because none is required. So I think the advice to consider getting a lien recorded sooner rather than later is especially apt for HOA Act communities. I think a lien is a good idea for most communities, right? But in particular for HOAs that do not have a resale certificate requirement. There's some related questions in the chat. Is it appropriate to add the lien release fee to the account along with the lien filing fee to ensure that the owner pays both? Usually, yes. Again, can't give legal advice for any specific situation, but generally, yes. Legal fees and costs incurred in connection with collecting unpaid assessments, which would include the lien costs and lien release costs, can be recovered from the delinquent owner. And then there's another related question. It says, in relation to that question, for buyers purchasing homes with cash, are they exempt from ordering resale certificates? No, they are not. However, just a point of clarification for how this actually works. The seller is the one that has the legal obligation to provide the resale certificate to the buyer. So the seller is the one, usually the seller's agent is the one who will contact the association, either the board directly if they're self-managed or the management company if not. And they might be the one that goes to, HomeWise or whatever website manages resale certificates for that community. It's the seller that has the legal obligation to provide the buyer with the resale certificate. That's a statutory requirement, and it does not change based on the terms of the sale, whether it's financed versus cash only. It doesn't change based on anything specific to the sale itself. It is the legal obligation of the seller to provide that resale certificate to the buyer before the sale. And also there's, I'd have to look up the statute to remember exactly what the timeline is. But once you've been provided with a resale certificate as a buyer, let's say I'm buying a condo and somebody gives me the resale certificate, I have a certain number of days in which I can look at that resale certificate and say like, whoa, there's a huge special assessment coming up. I'm out. And I can pull out of that transaction within a certain number of days of being provided with the resale certificate. So that's a little bit of an aside. It's not directly relevant to the question, but I think Tima is that all that boils down to saying, in addition to all of what Tima said, which is all accurate, in particular, single family home HOAs that don't have the resale certificate requirement, you guys should be looking earlier than another community might at getting liens recorded to protect your ability to collect at the time of sale because of that lack of a resale certificate requirement.
That's a good point.
Yeah. All right, our next question. In RCW 6438 communities, are ACC meetings open to the owners? And should the ACC be keeping meeting minutes? The short answers are yes and yes. So under the HOA Act, an association is required to maintain minutes or retain, minutes of all meetings of its owners and the board, other than executive session, and a record of all actions taken by the owners or the board without a meeting. So because the records section requires you to maintain minutes, and because what we talked about before with minutes, if it's not written down, it didn't happen. Yes, you have to be taking minutes. I guess I'm getting ahead of myself here. Our recommendation would be that ACC meetings be open to the owners, in particular if the ACC is voting and exercising the authority of the board. If the ACC is advisory only, then my answer to this question might be different, right? If the ACC meets, they look at applications, they make a bunch of notes, they maybe go look at the property or, call the architect and ask some questions. And then they put together a packet of information and a recommendation, which is provided to the board. And then the board is the entity that votes on the application. I might, in that scenario, say, well, they maybe don't have to take minutes. I mean, I would rather they take minutes, even if they're not actually voting. But often ACCs actually vote and make decisions that would otherwise be made by the board. And if that is the scenario, then those meetings should absolutely be open to the unit owners, and the ACC should absolutely be taking minutes of those meetings, because somebody say it for me, if it isn't written down, it didn't happen, right? So I will also point out all of these meeting related questions that we're answering today. Some of the answers you might not like very much because you've never had to do the open meeting thing. You've never had to handle meetings in this way. And you might already be aware that Wakaiowa for All is going to start affecting everybody on January 1st of 2028, right? But what you might not be aware of is that there's a bill in front of the legislature, or will be this session, that proposes to make the meetings section of Wakaiowa applicable to everybody early, January 1st of 2026. So part of why we are telling you guys all this stuff of just start having open meetings, just start having an owner comment period, just start providing this information to your ownership. We have long been proponents of open meetings, of transparency, of communicating with your owners, etc. That's always been true for us as a firm. But now more so than ever, with the prospect of you all being forced to operate this way starting January 1st of next year, which is the likely outcome, pretty soon you're not going to have a choice. And so you might as well start baby stepping your way there in advance, rather than feeling like, whiplash on January 1st when you have to completely change the way you've been operating if you are a community that has not yet started doing things like open meetings and such. So short answer, yes, they should be open to the owners, and yes, you should be keeping minutes. Tima, did you have anything to add, or do you want to jump to the next question?
I mean, I just think to that point, yes, there's a difference and a distinction between what's required and what's best practice. But if the standard of the best practice is higher than what's required, there's really usually not a reason not to go with the best practice. And so whether, like, as Valerie's saying, these laws may be going into effect soon and you should be doing it anyway. And we've been advising you of that all along. You should keep minutes. There's no reason not to. And it's a good practice for yourselves and for your ownership. The next question is, if the governing documents require open meetings with 10 days notice to owners, but also provide for special board meetings on 3 days notice to board members, must we give notice to the owners of a special meeting? I would go back to what I just said. Yes, the requirement is that notice of a special meeting is required. And the statute requires 14 days notice, except for emergencies that are specifically stated in 6490-502, and you can read those specifics. But and from an enforcement standpoint, courts in other states have found that the failure to inform owners of special meetings is a violation of the open meeting provision. So yes, you should give notice, and you should give 14 days notice unless it's an emergency. And that's a best practice, and it's also the requirement. Valerie, did you have any nuance on that?
No, I think you covered our position on it and how we view how we interpret the statute. So I think we can jump to a couple of questions from the chat since we have a few minutes left. One is, does the AI word for word transcript of a Zoom meeting constitute recording a meeting? You know, this is a great question. Our statutes haven't really caught up to all the technology that we have now. What I will say is, it certainly doesn't constitute the record of that meeting. It does not replace the minutes for that meeting, for example. And whether it constitutes recording the meeting or not is probably not super relevant legally, in my opinion. I think what's more relevant is how you're using that transcript. So I'm pretty sure that I saw the notification come at the beginning of this Zoom meeting, right? That there's an AI transcript being made of this meeting. I never look at those, so I don't know how accurate they are. I do know that I've seen AI transcripts of meetings or other recordings, and they're not always as accurate as we wish that they were. But if you're, for example, a board secretary and you guys are conducting a Zoom meeting and you take the transcript because you rely on that after the fact to go back and make sure that you didn't miss anything when you're drafting your minutes, I think that's a great use of that AI transcript. Whether it constitutes a record of the association probably depends on how long you plan to keep it and what you're going to use it for. So we do have clients that will either record the video of a board meeting or the transcript of a board meeting, keep it for 30 days so the board secretary can refer to it when putting the meeting minutes together, and then destroy it once the meeting minutes have been approved, because the meeting minutes are the record of what happened at that meeting. You don't want some other sort of competing irrelevant recording or transcript out there. You know, as a factual matter, I don't think a transcript is the same as a video recording, but I can't say that I've made that argument in court. And I think it's going to be really interesting to see how our courts deal with things like AI transcripts, because they are becoming so much more common than they used to be even a year ago, let alone longer. So that's maybe a kind of a squishy answer, but that's what I've got for you. Tima, did you have anything to add to that?
I don't.
Okay. All right. Let's see if we have another question we can squeeze in here. Any update on the CTA? Has the deadline been extended? There's not really been significant substantive updates. The most recent thing that happened is that the Supreme Court overturned the injunction saying that it was not enforceable, but FinCEN has continued to state that they're not reinstating the deadline and the enforcement plans. So that could change at any time. If it does change, we will definitely let you guys know. But that's the current status, which is that right now FinCEN is not choosing to enforce the CTA updating, reporting requirements. I think we're at 10:59. I don't think we have time for another question. So thank you all for being here, and we'll see you guys next week. Bye, everybody.